evening, and you could be doing a million other things right now, but you took the time to come here and learn about the very important topic of estate planning. And this is going to be a very informative webinar on why estate planning is so important. But we're going to take the time today to really focus on a couple key things. We're going to talk about what net law is and how we help you create your estate planning documents. In that, we're going to talk about each and every one of the documents and why they're so important. And we're going to talk in the end about, well, what happens if we don't do this and something happens? What are the ramifications to our family? So all of that will be covered in about a 15-minute presentation. And then at the end, we'll answer any questions that you have. But I think this screen kind of says it all. When people ask me, well, why should I do my estate planning? Why is it really so important? I like to show them this screen right here because it says everything about why we do estate planning without saying a single word. Family, right? That's why we do our estate planning. We don't do our estate planning for us because, well, we passed away. But what we do our estate planning for is when we do pass away, we want to make sure that everything that we have acquired throughout our lives gets transferred to our beneficiaries in the most cost-effective and time-efficient way. That's what we do every day at NetLaw. And we've helped tens of thousands of clients create their estate planning documents. So, probably the first question that you have is, okay, Mark, I get it. What's NetLaw, right? NetLaw is an IT company. We're a document creation company, and we were created out of an estate planning law firm in Louisville, Kentucky called the Hargrove Firm. That is our parent company. And the reason that our parent company, the Hargrove Firm, created this sub-company, this IT company called NetLaw is because way back in 2012, we read in a Bloomberg report that said that over 60% of Americans did not have a will. And that's worrisome, right? We're in estate planning. But 6 out of every 10 Americans are not coming in to see us to create their estate planning documents. Why? So we did our research, and there were really a couple reasons why. One is cost. It's very expensive to go in and see an attorney and get your estate planning documents created. So we had to come up with the solution for that. But the bigger reason was people always thought that they didn't have enough assets or enough money to do their estate planning documents. And that's the biggest misconception of them all. Because anyone over the age of 18 needs to complete these documents. You need to make sure that whatever you have is listed in these documents so there's no court interference, no state interference, and everything gets passed to your beneficiaries right away. So how did we do that? How did we solve both of those issues? We created NetLaw. NetLaw, again, is an IT company and a document creation company. So what we did is we created our software that financial agents can send out to their clients to help them create their estate planning documents without the need of going to an attorney's office. How did we do that? We hired attorneys in all 50 states to come in and create our software. So our software has been developed by attorneys in all 50 states. And the reason that we needed every attorney from every state to come in is because each state has their own rules and regulations. I'm in Kentucky. So what's legal and rule abiding, according to the American Bar Association for the state of Kentucky, is different than California, is different from Texas, is different from Virginia, so on, so on, and so on. Every state has their rules and regulations that have to be followed. You probably know it better at the term state-specific documents. When you use our software, your clients or you will receive state-specific legal documents where an attorney from your state has created these documents. And there's 2 things that separates NetLaw from everyone else in this industry. The biggest is NetLaw was awarded the James Keene Award from the American Bar Association. This award is handed out each year to the company that has the best online delivery of legal documents. And I'm going to say that again because it's important. from the American Bar Association, the best online delivery of legal documents. That was awarded to the Hargrove firm for their creation of NetLaw. So when people, and they always ask me, well, shouldn't I go see an attorney for this? And I always say, sure. If you want to go see an attorney for this, there's nothing wrong with that. But from the statistics, we know that you're not going to do that, right? People procrastinate. No one ever wakes up one day and says, I'm going to go sit in an attorney's office for 2 or 3 hours and talk about what happens when I die. We're just not built like that as humans. But we will do that in the convenience of our home. That's why NetLaw is so powerful. And these are all the documents that you get in our premium probate avoidance package. These are all the documents that you will need to create your full estate plan. And the great thing is you can see it in the middle of the screen. One plan covers both spouses. So you purchase the plan once, and both spouses get to create their full set of documents. Now, let's run through these documents and talk about why they're so important. Most people, when you start talking about estate planning, will say will and trust. Let's remember that your will and your trust are 2 separate documents, and they're going to do 2 totally different things. I love the will. To me, the will is the most important document. Here's why. Think of the will as your listing document. This is where we're going to list everything that is important to you. We're going to list, number 1, executors. These are the people who are going to be in control when you pass away. Who's going to handle everything when you pass away? Your executor is responsible for paying your taxes at the end of the year. They're responsible for distributing all of your assets to your beneficiaries. They're responsible for paying off all of your creditors. They're responsible for filing your will with the county records department once you pass away. 2 things about your executor. 1, they have to be over the age of 18. The second, and I always get this question, can my executor be someone from overseas? Yes. But with this plan, not only do you name main executors, but we get to list alternate executors. They're called successors. We call them backups. If your main person can't do something, who's the backups that can play the role of your executor for the person who can't do it? This comes in handy if you're naming a main executor, someone from overseas. You need to have someone listed from your state who can do the legwork, who can go to your house, go to your work, go to your bank. So yes, you can name a main executor, someone from overseas, if you want. But make sure that you're naming at least one person from your state to be your successor, because there will be legwork that has to be done. Number 2, guardians. If you're a parent of a child or children who are under the age of 18, if something happens to mom and dad, plane wreck, car wreck, COVID, we saw it with that a lot. Both parents pass away, and there's underage children. Who's going to have custody of your kids? We're going to name guardians in our last will and testament as well. Again, you're going to name main people and then successors. Last reason we do our will is we're going to list all of our major assets and who the beneficiaries are, because the last thing we want is any kind of family fighting. Because there was no will in place, the family comes in and starts fighting over everything. When you create your will, we're going to list all of our assets and who those beneficiaries are. So you stay in full control of everything. Second line item is the children's trust. This is for those parents that have underage children. If you do not create your will and you don't list your guardians, so if both parents pass away, when does the child receive their inheritance? Again, if you do nothing, age 18. Your child will receive everything at age 18. And that sounds great, right? Both parents are passed away. Let's get the money to the kids as soon as possible. Here's why it's not a good idea. They're 18. And we're going to think about what they're going to receive in today's world. Proceeds of the house, proceeds of any other house that you own, bank accounts. If both parents are working, 2 401ks, and hopefully 2 life insurance policies. That's easily $1 million right there to an 18-year-old. What do you think an 18-year-old is going to do with $1 million? You think they're going to call Karthik and say, I've got $1 million, what do I need to do with this? Or are they going to go out and just blow it? You're right, they're going to go out and blow it. Because I know I would have done that at age 18. Children's Trust allows parents to dictate how much of the inheritance the child will receive at a certain age. You can string it out all the way to age 35 if you want. Parents love that option. Third line item, power of attorney. We all know what that is, right? Our power of attorney. Naming someone to make our financial choices for us if we're incapacitated, whether we're sick, we're in the hospital. Maybe it's for when, 40, 50 years from now, we're in our 80s, we're in our 90s. Hey, our minds just aren't as sharp anymore. Let the kids come in and take control of everything. Having someone who can make our financial decisions for us while we're alive, but if we can't make them for ourselves. Very, very powerful document. In the beginning, I said this was a full comprehensive plan. So not only are we taking care of your finances, but we're going to take care of your healthcare decisions as well. Healthcare surrogate is your medical power of attorney. Who's speaking to the doctors and nurses on your behalf if you can't speak for yourself? And your HIPAA authorization grants access to all of your medical charts to your healthcare surrogate or anyone else that you name so that they can have that informed decision. And your advance directives are your end-of-life decisions. Keep me alive as long as possible. Do whatever it takes. Or the opposite. I'm stage 4 cancer. I know I'm passing away. Keep me out of pain, but let me go ahead and pass naturally. What do you want to happen? You kind of see the main theme of all these documents, keeping you in control of everything. All of your decisions are going to be taken care of upon your wishes. We even have a pet trust. So if you're a pet lover, you leave money behind for the well-being of your animals. And then I think the biggest document besides the will is the trust. That's why we always say will and trust. Remember, your will was the listing document. We listed who our executors were, who's going to take care of our kids, and all of the assets that we have and who the beneficiaries are. Your trust is the holding document. This is where we create a revocable living trust, and we can transfer all of our major assets that do not have named beneficiaries. I'm going to say that again. This is where we can transfer all of our major assets that do not have named beneficiaries, like our homes, rental properties, businesses, boats, cars. We transfer all of those assets out of our individual name and we place them in the ownership of our trust. Why do we want to do that? So that we avoid probate. Probate is a bad word. We do not want to go through probate. Probate happens when you pass away. You do not have a trust in place. The state comes in and freezes all of your assets that do not have named beneficiaries. Probate lasts 6 months up to a year in every state. So those assets sit in probate and are not passed to your beneficiaries. But if you transfer those assets out of your name and into the name of the trust, when you pass away, those assets pass to your beneficiaries right away. The trust is the only document that allows your assets to avoid probate. A will does not. So when people say, should I have a will or trust? I always say both. Because the will is dictating who's getting what. The trust is saying they're getting it right away. And we even have a 7-day money back guarantee. Try it out. As long as you haven't downloaded any of your documents. If you don't like it in 7 days, we'll give you your money back. All of this, again, is included for both spouses. One plan, both spouses get to create their full set of documents. And I said that there were two things that separated NetLaw from everyone else. One was the James Keene Award. Remember? The best online delivery of legal documents. Here's the second. Not only do you have the ability to create your documents, but anytime there's a life event, you have the full ability to log back into your account and edit your documents free of charge. Most companies charge $10 to $30 a month to keep your account open and active. We don't charge anything. You pay the one-time fee, and you have full, free, lifetime access to your account. So there's no reason why you should never have the most up-to-date documents possible. Just remember, when you create your documents or you edit a document, you have to print them out and get them witnessed and notarized. That's it. So why is estate planning so important? Well, we kind of talked about it, right? We talked about the need of why a company like NetLaw was created. Cost effective, time effective. You don't have to go see an attorney. And you have the ability to create your documents and edit them at any time. But the last 4 slides I'm going to show you are probably the most educational. Because now we're going to talk about the ramifications to your family if you don't do this. This is not a scare tactic. It's just education. What happens if I don't have this and I pass away here in the U.S.? Most people just assume that if I pass away, my spouse gets everything. That's not true. So the only legal term I'll use tonight is intestate. Intestate means that you passed away and you did not create a will. So your state comes in and says, you didn't tell us how you wanted your assets distributed. We're going to do it for you. The state will dictate how all of your assets are distributed. This plays a role when if you own an asset by yourself, or if you're married and you're the second spouse to pass away. The state will dictate how your assets are distributed. No one wants that. No one wants the government coming in and making any decisions for us, let alone who's getting our assets. But when you create your will, remember, we're going to list all of our assets and who those beneficiaries are. And it's going to stop all the family fighting. This is the first slide that I always show my clients when they come in and talk to me. Unless I know they have children under the age of 18. Then this is sometimes the only slide I show them. What parents don't realize is if you pass away, you and your husband or wife, and you have children under the age of 18 and have not done a will, a judge will dictate who gets custody of your kids. Now, there's 42 of us on here. I guarantee we don't agree on everything. But I guarantee all 42 of us will agree that we do not want a judge making the decision of who's going to raise our kids. We create the will. We name our guardians. Not only will the judge make the decision of who's going to raise our kids, but that person will have full control of our inheritance that we leave behind for the kids. Easy decision. This is why we do it. Transferring those assets out of our name and into the name of the trust keeps our beneficiaries and executors out of probate court. The one thing that we don't want is for our beneficiaries to go through probate court. Like I said, it's time consuming. 6 months to a year. Those assets will be frozen. If you fight the probate process, you can hire an attorney and you can go to court and battle all the creditors. That's going to cost you probably 10 grand. Easily. That's money that should be staying with the beneficiaries, who are usually your surviving spouse and kids. It's simple. And I know when I sit up here And I say, just transfer your assets into the name of the trust. It probably sounds complicated to you, but trust me, it isn't. We have a funding instruction sheet that walks you through how to transfer your major assets into the name of the trust. And I'll tell you, most people with their properties, you just take the certificate of trust with us and the deed of your house, the deed of your property. You can take both of those items down to the county clerk's office and get a new deed in the name of the trust. That's it. I did mine about 3 years ago. It cost me $79 and it took me about 20 minutes. Very simple. Last slide. Don't skip out on the medical documents. They're just as important as your financial documents. Having someone in place who can talk to the doctors and nurses to let them know what you want to happen and what you don't want to happen. One thing we don't want at end of life for you is to have your family fighting over the care that they think that you might have wanted. We do all of these documents while we're young, while we're healthy, while we're in the right state of mind, so that everything is taken care of. That's what we do every day at NetLaw. We keep the process simple. It takes about 30 to 45 minutes for both spouses to create their documents. Or you can go to an attorney, spend $3,500 up to $5,000, and stay there for about 2 to 3 hours. It's easy, it's affordable, and you have unlimited access to your account so you can update your documents free of charge anytime.